And when it came to this case, I have a feeling that the story started and the work started way before trial, as most of them do. And a lot of us jumped in and watched the trial. But what were some of the major issues and hurdles you had to get through just to get this case before a jury?
Yeah, I think that, if you ask folks in the, legal community, especially in Virginia, this was kind of a lame duck early on. And that's because we have a very stringent workers' compensation bar in Virginia, which means that you can't sue your employer or co-employees, but for certain exceptions. And so we knew from the outset that we would be asking the court to recognize this as essentially an exception to that limitation in bringing a lawsuit. And that's where we focused a lot of our energy early on. We also knew that if and when we overcame that hurdle, we'd also have to face what is still alive and well in Virginia, which is sovereign immunity. And so the school board, I know that there are a lot of questions, at least friends and family have told me a lot of questions online about the school board and the
Mm-hmm.
school system. And so we knew that we were going to have to get over the comp issue, and we'd have to get over sovereign immunity, or at least get past it somehow and navigate through it. And then, we had a coexisting criminal case at the same time, which we knew would or could result in delay in our case. And so it was, there was a lot of chess moves, to try and get us to where we were in that, October trial date of 2025. And, fortunately we overcame a lot of the hurdles. We lost some as it relates to sovereign immunity, which we can talk about. And
Yeah.
and ultimately, uh, we've what I think you asked me earlier, how did it feel to get the verdict? It was a relief. It's also a really gratifying experience as a lawyer to think, okay, we've actually charted a new path for people to potentially recover in circumstances like this. And I think that is something since the verdict that has probably struck me the most in terms of, this issue of being able to sue a co-employee as a teacher. It was really not attempted in Virginia or elsewhere. And so, there were hurdles, and we navigated them as best we could.
Yeah, and you could feel a lot of that, and a lot of people were asking questions like that in the trial. So I wonder what the jury was thinking. I'm sure you dealt a lot with this in jury selection, but let's take them kind of in turn. So the first one you talked about was work comp,
Yeah.
and just to make it on as basic of a level as we can for anybody listening, most work comp scenarios is you get hurt at work. Let's say you work at McDonald's, you get hurt at McDonald's. They have work comp insurance, they pay for your medical bills, but you can't then go and also sue McDonald's because that bars it by work comp. But if somebody were to come in to McDonald's, a patron, and punch you in the face and you get hurt while working at McDonald's, you can still get work comp from McDonald's because you got hurt at work, but a third party is at fault, the guy that came in and punched you. So you can sue that third party. But in this scenario, because it's a co-employee also at work, how did you guys get through that and navigate it? You said you kind of used some exceptions to be able to continue forward.
Yeah, so I think that was a great summary. First of all, the way that we overcame it in this context is that there was some case law in Virginia before this that talked about whether something was an expected injury on the job, and if it wasn't expected or part of the job or part of the job description, so to speak, then arguably it didn't fall within the confines of the workers' compensation statute.
Hmm.
And then additionally, there are other cases that sort of talked about how in the event that something was personal to an individual, that is a way for the courts to distinguish what is expected and not expected. And what we mean by that is, if there's a type of injury that happens more commonly across the board to people, even if it's not something that you would see routinely, the courts say, well, it's it, it's not routine, but it seems like this is something that happens enough that it's not personal to the employee. It is a more general risk to the population of workers in this class. And so our theory, and I believe it to be true, and it proved to be true in the court's rulings, and we may have to deal with this on appeal later, is that what happened on January 6th, and the reason that the news cameras and we're talking about it likely today is that it was totally unexpected, right? It was not expected that a school teacher, at least a school teacher for first graders, would be shot by a first grader, and that first grader would make comments that effectively reflected that I did this to you. I meant to do this to you particularly. And that is reflected in some other evidence that didn't really come up at trial because it wasn't pertinent. But because of those balancing factors, we felt, okay, we think that we can really pursue this justly and rightly and say that, okay, while there may be some risks involved, and when we argued the workers' compensation statute, I remember the judge had asked me in oral argument, well, what makes this case different? And I said to him then really what I said in closing argument, which is a gun changes everything. And the gun, we wouldn't be here if we're talking about a student that threw a paper clip at somebody and scratched their hand, or took a pair of scissors and threw it across the room and injured a teacher. What we're talking about is a gun, and the gun is unexpected, and the gun was personal to Abigail Zwerner. And that's ultimately what the court reasoned in deciding that the workers' compensation statutes in Virginia didn't bar the suit. So we overcame that. And at that time, it was both against the school system and the co-employees. That was the first thing that was really heard.
Yeah. And whenever you have a big decision like that, that is kind of groundbreaking, it's awesome, it's exciting, you're doing legal work, you're in the trenches, but there's also always in the back of your head, like, those are the ones that get appealed. Those are the ones they feel confident appealing, as opposed to, like, I just had a verdict appealed last year and everybody knew it was going to happen. But of course they have to appeal it because they're going through the process because they don't want to pay. So it's like, there are different appeals, and those appeals, we had a case, I don't know if you heard anything about it, the Take Care of Maya Netflix docuseries was here. Huge, hundreds of millions of dollars in a verdict, some strange rulings that kind of got us there, but you can understand where the judge was coming from, and the whole thing gets overturned and now remanded back for another trial. So, those are kind of when you have groundbreaking things go in your favor, but you get the opportunity to get it in front of a jury and see, what does society think about this? And so many people had the question throughout the trial, like, what's the difference between a teacher getting shot and a student getting shot? And kind of what you explained is the difference in how there wasn't really an avenue before to go through it because of workers' comp.